is you must learn the mindset to negotiate successfully. And I'm going to talk about that mindset. And how do we get there? How do we have a different mindset when we go into mediation than we would if we went into a trial? And whenever you're dealing with people, whether it be your client, whether it be the opposing side, whether it be the mediator, whether it be a third-party consultants, you all have to take into consideration their perspectives. You may not agree with the other side, but if you look at it and you put yourself in their shoes, you should always be able to understand it. This will lead you to build trust.
Welcome, and thank you for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, John C. Sciaccotta. John C. Sciaccotta is an Arenberg Goldgein Senior Equity Partner, the immediate past president of the Chicago Bar Association, and is a member of Arenberg Goldgein's Executive Management Committee. He specializes in trial and litigation with nearly 40 years of work in complex civil litigation, mediation, arbitration, and business counseling. John has a particular focus with complex civil trial and appellate cases, which are brought in federal and state courts and tribunals all over the United States. John represents publicly and privately held domestic and foreign business entities, lenders, employers, municipalities, government bodies, and individuals in transactional matters and disputes. The webinar presentation that you're about to watch will be approximately 75 minutes, and time permitting, John will be taking audience questions once the webinar is complete. So if you have questions at any time and you'd like to drop them in the Q&A box, you can go to the control panel at the bottom of your screen, click Q&A, and submit your question there. Now, without further ado, here is John to discuss how to excel in negotiation and mediation, the secrets for success.
Thank you, Nina. And welcome, everyone, very much. It's a great privilege to be here today. And I am excited about this topic. And I hope that after this program, you will feel more confident in your representation of your clients and also feel and have a great amount of confidence in going into any negotiation and mediation. What's going to be unique about this program today is that I am going to talk to you from a number of different vantage points. I'm going to talk to you from the advocate's vantage point, of which I have been a lawyer nearly 40 years. I'm also going to talk to you from the mediator's perspective, because I'm also a mediator and an arbitrator. So I think that gives you a very unique perspective of seeing the art of negotiation and mediation from different vantage points. And I think that is significant, and that will assist you and your clients in negotiating in mediation and otherwise the best outcomes that you can possibly get for your clients. The course overview will explore the best practices and strategies for how to be a great negotiator and also how to participate effectively in mediation. I think at the end of the day, you'll gain, hopefully, insights into overcoming common challenges and utilizing some of my secret techniques and strategies that I've developed over nearly 40 years. This is who I am that you've already heard of. Let's talk a little bit about what we hope to get out of this today. I think one of the things that we want to is, and I think one of the most important focuses on any negotiation, is you must learn the mindset to negotiate successfully. And I'm going to talk about that mindset. And how do we get there? How do we have a different mindset when we go into mediation than we would if we went into a trial, for instance? It's a different mindset. It's something that I think lawyers, for the most part, have to shift gears and put on a different hat when they go into the negotiation and mediation process. It's easier said than done, and I hope I'm going to give you some tips that will allow you to be able to do it easier in order to benefit your clients. We're also going to talk about understanding the strategies and challenges involved in negotiation and mediation. This is very difficult work. It is hard work, negotiation, strategies, the challenges. You're dealing with, people, right? And whenever you're dealing with people, whether it be your client, whether it be the opposing side, whether it be the mediator, whether it be a third-party consultants, you all have to take into consideration their perspectives and how they are looking at it from their vantage point. And one of the arts of being a terrific negotiator that we're going to talk about today is how do we put ourselves in another person's shoes? And how do we see the perspective from their perspective? If in fact you can do that, and you can do that readily, you will be a successful negotiator, and you will also excel in the mediation process. So we're going to talk about that. We're also going to identify the strategies and challenges to prepare clients for the negotiation and mediation process. This isn't just about showing up with your client to a mediation. There is so much more that is required and necessary, absolutely necessary, to be successful in any negotiation, and especially a mediation process. Many times lawyers show up with their clients are unprepared, the lawyers are unprepared, and the process breaks down because there has not been adequate preparation. If there's anything we know as lawyers, you have to prepare for anything that you do in order to be successful. And lastly, what we're going to talk about is understanding the post-mediation strategies and process. If we get to yes, which is ultimately the goal, how do we document that? When should we document it? And how should we document it? I think these are very, very important learning objectives that at the end of this program, I'm hoping that you have a better handle on all of these to be successful in any negotiation and mediation. Okay. One of my favorite topics, negotiation mindset. What is it? How do we get there? And what are the proper techniques to allow us to get there? And by the way, this is not only a negotiation mindset for lawyers, but it must be a negotiation mindset for the clients. I want to repeat that. It's not just for the lawyers, but it should also be for the clients. And that might be the first time that you hear this, but I will tell you that it is so important, because any negotiation and any mediation that is successful, you have to prepare the clients. You have to get them ready. And for them to be ready, you have to get into what I call the negotiation mindset. I should actually trademark that. I'm just kidding. Okay. What is it? The win-win mindset. What is the win-win mindset? How do we get there? How do we develop this with our client? I think the first and foremost objective to get into the win-win mindset is to discuss with yourself and with your clients the common interests that you both have and objectives for purposes of any negotiation and any mediation. What I do in this regard is I get out my yellow pad and I draw a line down the center. I then draw a T at the top. I put client A and I put client B. And I talk about and I write down what are the common interests and what are the common objectives of each of the parties. And it could be that, client A owes client B some money or claims to owe them money for breach of contract. But what are the common interests that they both have? What are the common objectives? They'd like to resolve this, right? Rather than spending more legal fees. They'd like to resolve it so they could cut off the risk. They'd like to resolve it so they have more certainty in their lives, right? They like to resolve it so they could move on to something else. So it's the win-win mindset, I like to call it. And that means you need to identify at the outset of any negotiation what are the interests and objectives that you both have in order to have the resolution or a potential resolution to be a win-win for each of the parties. This takes more time than you think. It also takes an inordinate amount of time with your clients because the client's viewpoint and perception may be much different than your perception. And more than likely, it's much different than the opposing party's perspective and viewpoint. So we need to identify where are we aligned. Let's go in with a win-win mindset. We do agree on certain points. And what are the other points that we don't agree upon? I think this is significant. The other part that is really part and parcel of this is open-mindedness. I can't tell you how much I speak to my clients before any negotiation, before any mediation, about being open-minded. And notwithstanding that, when I am a mediator, I talk repetitively about being open-minded to different perspectives, different approaches, different strategies, and also to be creative and open to alternative solutions and changing perspectives, right? I think one of the arts of negotiation, and that I think great mediators have really a gift at, is coming up with solutions to problems that are outside of the box, that really give the parties a different perspective that allows them to maintain a win-win mindset. I think this is key. I think this is something that you always have to talk to your clients about, and you can never talk to them enough about open-mindedness. Open-mindedness is something that is so important. And I'm going to go back to open-mindedness throughout this presentation today and talk about it because I think it's something that sometimes we as lawyers overlook. And by the way, I also think lawyers overlook it. Okay. I think sometimes lawyers aren't open-mindedness. And for the most part, in many instances, they're closed-minded. Okay. They see the case or their positions or their claims from a very narrow lens. And I think when you go into a negotiation and especially into mediation, you have to broaden that lens. The lens has to be not narrow, but it has to be wide and all-encompassing, and it has to trigger an open-mindedness perspective. The other negotiation mindset that I think is somewhat underestimated and not always concentrated is having an empathetic approach. I can tell you as a mediator, I am empathetic always to the respective parties' positions. I am always very understanding of them, notwithstanding the fact I may disagree with them. But I think also as negotiators, you have to always allow the other side some empathy that you understand their position. You may not agree with that position, and more than not, you don't agree with it. But that doesn't mean you don't understand where they're coming from. And I think many times understanding where the other side is coming from builds a trust and builds a rapport that will allow you to be a better problem solver, and in more instances will allow you to resolve the matter. I'll tell you just a little quick story. I was in a mediation one time as a mediator, and usually in a mediation, I bring all the parties in to the initial caucus. So all sides were in on this caucus. And I started talking about the case, about win-win mindset, that this is a negotiation, this is a mediation, we're trying to get to yes. In fact, we are going to get to yes. And then, of course, I went into my open-mindedness spiel about we have to be open-minded, we have to be willing to think outside the box. And then I talked about empathy. And one of the other lawyers got up and said, I can't have any empathy in this case because the other side is wrong and there's nothing that could change my mind. And so right off the bat, I was fighting uphill. We eventually settled that case, but I was fighting uphill because the other lawyer told the other side that they didn't understand their position. And even though they didn't agree with it, you have to be able to understand it. And you also have to allow your clients the ability and talk to them about, you may not agree with the other side, but if you look at it and you put yourself in their shoes, you should always be able to understand it. This will lead you to build trust and lead you to be able to a better chance at resolving the dispute. Okay, let's talk a little bit about mediation and negotiation strategies, right? Strategies, techniques are going to be something that we're going to talk to a lot about today. I can't tell you how important it is in both your written and verbal communication to be clear and concise. When you are with the mediator as counsel, it is very important that you communicate your position clearly and concisely. It is also very important for the mediator, who will also be, and all mediators that are any good are great listeners. The mediator is going to be listening to exactly what you're saying, how you're saying it, and are also going to be reading your body language. And we're going to get into nonverbal communications, okay, later on. But one of the key points that I want to make here is that you must be clear and concise in your messaging, because any unclear message that you pose to the mediator or you pose to the other side, that is not going to allow you to advance your position with respect to getting to yes and to resolving the dispute. The other mindset and strategy here is to create a mutual value. What do I mean by that? One of the key components here is when you create mutual value. And what I mean by that is you identify common interest of both of the parties that must be addressed. In other words, you need to identify where we are aligned and where we are not aligned, okay? Once you understand the alignment of the interests and that you can identify where we are in agreement and where we are in disagreement, you're creating mutual value. Mutual value is significant. Wherever we can cross out, and like I said to you, I draw a T and I write down all the points and I check mark where there are mutual interests and mutual values and common interests. Where we have common interests, okay, we can use those common interests strategically to identify those areas where we do not have common interests and be able to negotiate off of that. We're going to talk about that a little bit later as well. One of the other strategies that I think lawyers and clients need to work at and need to work at all the time is to be adaptable. You have to be flexible. Every mediation or negotiation we've ever been at, any of us, things change. Sometimes the facts change. Sometimes the circumstances change. Sometimes your priorities in terms of what you went into negotiating wanting versus to what you might be able to obtain they change. So, and it's difficult for clients to be flexible. Okay. And so it's very incumbent upon the lawyers to prepare the clients for possible different outcomes that still may be positive. And these being adaptable, being flexible will allow you to facilitate positive outcomes that may not be what you went into the negotiation thinking about, but it's coming out of it to be satisfied. And I think this is a very important item that both lawyers and clients need to be prepped. You need to prepare them for flexibility. You need to prepare them for being adaptable. You need to talk to them about possible outcomes that may present themselves in the mediation, in the negotiation. And I think that's significant for them because in their mind, they'll be able to sort out the fact that there may be alternatives. And if in fact there are alternatives, this is something that I think is very significant. Okay. In all negotiations, in all mediations, we all know there are challenges. And these are challenges that we have to be prepared for. We have to talk to our clients about. And we ourselves, as lawyers and advocates, we have to be ready for them. We have to prepare ourselves to be ready for the challenges. And let's talk a little bit about some of the challenges. Well, we've all been here, probably more often than not, dealing with the high conflict personality person, right? The hard bargainer, the hard charger, the person that walks in and is beating on the desk, right? How many of us have heard this? How many of us have witnessed this? We've witnessed it in court. We've witnessed it in depositions. We've witnessed it over the phone. We have witnessed it, obviously, in negotiations and in mediations. These are individuals that also love conflict, are highly charged and emotional. They love to derail negotiations because that is part of their technique. Their technique is to take you off your game. Their technique is to throw a monkey wrench into your plan of attack. Their technique is to diffuse and divide and to destroy your win-win mindset, right? They don't want to talk about where you agree, the points that you agree on. They're not interested in that. They're interested in bomb throwing in order to get you off of your plan of attack. Here's what you need to do. And by the way, I've been in negotiations, I've been in mediations where I've walked out of the room. I've gotten up, I've walked out of the room, I didn't say anything, I didn't look at them, and I just made them sit there. I had them sit there and let them stew after they've gone on ranting and raving. So the key to dealing with the hard bargainer is to stay calm, with them and to redirect their focus to where we want to be, and that's the win-win mindset, the shared objectives, the shared interest, and establish boundaries also to maintain a productive dialogue. One of the ways that I do this is I try to distract them. I try to turn the subject around, or I try to change the subject. Many times they'll be saying, your client is wrong. Your client did this. Your client breached the fiduciary duty. Your client stole from my client. I'm involved in a lot of business divorce, shareholder partnership, member disputes. And it's always that this person was stealing from them and they're not pulling their weight. And what I do is I try to change the subject. I try to change the subject. And sometimes I will say, to be honest with you, your client isn't all that bad. And they'll look at me, quizzical. Actually, I think your client provided a lot of positive direction to the business. And they're like stunned, that I'm sort of saying how great and majestic their client is and magnanimous. And then I will then turn them around to where I want them to go in terms of redirecting their perception. Okay, because they're coming in with a perception of the case that your person is bad and that their client is good. But I also want them to look at the fact that there is some good in my client, there is some bad in your client. But you must be able to do this staying calm and redirecting the focus. And that's one technique that I've used very successfully. Let's talk about addressing the power imbalances between the parties. This is many times always the case, right? There's different balances as it relates to wherewithal. There's different imbalances as it relates to control. There's different imbalances as it relates to personality. There's different imbalances relating to either being conflict adverse or loving conflict. You have to be able to understand the roles of the parties in the litigation, but also outside the litigation. And what I mean by that is you need to understand the personalities of the parties in order to identify how to address the power imbalances. As I indicated to you, I do a lot of business divorces. And so many times these are companies that were started by grandparents and then parents, and then it's down to the children, right? The third generation. And many times there are old and deep-seated issues that siblings or cousins or family members have that go way back and have really nothing to do with the current circumstances of the present dispute. But these are issues that fester themselves. These are issues that raise themselves in litigation and in negotiation. So you have to be aware of what are the power imbalances and what are the personalities of the parties. I can't tell you how important this is. I could spend an hour just on this subject matter alone in terms of when I'm an advocate, how I address the other side. How do I analyze the other side? How do I analyze the other side's personalities? How do I analyze the other side's claims? But I also have to look at my clients as well, right? And when I'm a mediator, of course, I'm looking at both sides. I'm looking at, what are their viewpoints? What are their power imbalances? What are they stuck on? What are their objectives, right? I also think that this is an opportunity, and I believe that life is all about needs. This is an area then that you can identify what are the needs of the parties, right? Many times in these types of cases, business divorce cases, we're dealing with people with big egos and we're dealing with greed. And so we need to understand what are the needs of these parties, right? What do they need to survive? Is it saving face? If in fact it's saving face, then how do we devise a resolution that saves them face? These are the dynamics that you have to go through and you have to understand in terms of the parties and the power imbalances that creep up in these circumstances. The other challenges, of course, that we see all the time, every day, is how do we overcome impasse scenarios? How do we overcome when one of the parties says, I'm just not going to be able to get there today. I'm just not going to be able to come up with that kind of money today. maybe another day, but not today. How do I keep them, or how do we keep them as advocates in the game? But how do I, as a mediator, keep them in the game? And what I do is I begin to reframe issues. I begin to go back in time in terms of where we've been in terms of the negotiations. And I bring them back, and many times I get out my legal pad and I start talking to them about, okay, you want to walk out of here today? How many depositions do you have left in the case? Oh, I got 10 depositions left in the case. Okay. Each deposition is going to cost you this much, and that's fact depositions. Then you have expert discovery. How many experts are there in this case? And how much is their report going to be? And how much are the depositions going to be? And then you're going to have pretrial memorandum statements due, especially if you're in federal court. Obviously, those are so much work. And I start adding up the expenses, right? And more often than not, when I begin adding the expenses that is going to take you from today to a year from now, and getting ready for trial, and preparing the motions in limine, and preparing the witness prep and the jury instructions, or if it's a bench trial, obviously a little bit different. But and then again, I also indicate, well, maybe a motion for summary judgment is going to be filed. I try to reframe it and sometimes even take away the present dispute. And I start talking about economics and finances. And I start making them understand and reframing the issue of financial consequence as well as risk, right? Because what moves people is when they do something when they need to do it, when they feel compelled to do it, when they feel that there's a risk that may be associated to them. That's when people move. They move when there's risk. They move when there's a downside, when there's potential exposure. And obviously finances and financial consequences is an exposure. So this is something that I think many times can get us past the impasse scenario, and I've been able to use it very, very effectively. Managing unrealistic expectations. Wow. How many times have we talked about, managing unrealistic expectations? And let me tell you, I, as an advocate, and I also do this as a mediator, I have a pre-hearing in mediation when I talk to the lawyers. And many times I talk to them in caucus, and I also talk to them together. But every single time I try to manage the unrealistic expectations. When somebody is telling me they want $1 million when the claim is $250,000, I have to be honest with them, and I have to tell them right out that clearly your expectations are not realistic, that this is not going to be obtainable. It does not do me any good to sit there and try to talk to somebody about a resolution when their expectations are so out of reality. This is something that you have to spend an inordinate amount of time with your clients on, because many times clients obviously see the case the way they want to see it, not the way that it is in reality. So it's really important for us as lawyers to sit down with the clients. And sometimes we have to tell them what they don't want to hear. I think that's part and parcel of being a great lawyer, is sometimes having to tell somebody what they don't want to hear. I can tell you as a mediator, I do that all the time. But I do it in a way that doesn't bruise them. I do it in a way that makes their perception and viewpoint change as to why it's unrealistic. And that's really an art. I could spend an hour or two just on that subject matter. But how do I change their perception? That's what negotiation is about. That's what mediation is about, is changing people's perception. And managing unrealistic expectations is a huge issue that comes about in every case. You also, in many different types of cases, you need to navigate the cross-cultural differences, right? There may be parties that come from different cultures, different backgrounds, different ethnicities, different countries that view things a little bit differently than we do here in the United States. This is something that you have to understand going into the case. You also have to understand it and make your clients understand it. That the folks that we are dealing with on the other side, they come from a different perspective and they come from a different culture. And let's use the differences in culture to our advantage rather than to our disadvantage. I think that's very significant. And you're seeing obviously more and more of this, especially in international arbitrations and mediations, when you're dealing with parties from all over the world. You're also dealing with it sometimes when you have senior executives at companies in the United States with different cultural perspectives. It's important to understand them. It's important that you know or have a better understanding of where they're coming from. Dealing with lack of preparation. This is always very frustrating for me, not only as a lawyer, but especially as a mediator. I can tell right away when a client is not prepared and when a party is not prepared. I also can tell when the lawyer is not prepared. And I can tell right away when the client has not been prepared by the lawyer. And so what do? I quickly begin the process of preparing the party, the client, and also I begin the process of preparing the lawyer. So it's more work for me and it's more work for you as an advocate and for me as a mediator and an advocate. When I know the other side just walked in here and didn't do anything to prepare for this negotiation or mediation. This is always problematic, but you need to recognize it. The key, and remember what I'm saying here, the key is to recognize it, because upon you recognizing it, then you're better able to deal with it, okay? I know right away when this happens. As soon as it happens, I change gears and I begin the prep process. And it's very important for you to do that as well when you are, in fact, getting ready to negotiate and going into mediation. You need to know whether or not the other side, both the client and the party, are prepared. And if they're not prepared, one of the things that I always do as an advocate is I tell the mediator that the mediator needs to get them prepared and needs to talk to them about reality and needs to get them prepared and bring them into reality where many times they're on Mars. So this is a very important point that you must identify. And by the way, any experienced mediator, they know when this happens and they go into action. Okay. Let's talk about this, the pre-mediation conference with the arbitrator. I can't tell you how important this is for the lawyers, for the advocate. I mean, this is your chance to educate the arbitrator and the mediator, okay, what is going on in this case. So this slide should be pre-mediation conference with arbitrator and or mediator. We're going to talk about the mediator. This is where you get to tell the mediator or the arbitrator your theory of the case. This is where you get to tell them the opening statement, right? And many times it's outside the presence of your client. And it's also sometimes, and I have a pre-mediation conference, I caucus with both sides alone. It's where you can tell the mediator, hey, Mr. Mediator, I need help on this particular issue with my client. And this is why. It helps me as a mediator. It helps me do my job. It helps me perform because I'm going in there knowing what I need to do in terms of connecting and resonating with the client. Because in any mediation, great mediators, in order to be effective, you need to connect. You need to connect with both the client and you need to connect with the advocate, the lawyer. If you're able to do that, you're better able to get them to see a particular viewpoint a certain way. So I think you need to present a clear, concise narrative that highlights the strength of your position and also aligns with your client's goals. And by the way, I also think in that regard, in order to gain credibility with the mediator, it's important for them to let them know in your own way, what are the weaknesses of your case? And where do you see some weakness? Because in every case, there's strengths and weaknesses, as we all know. And it's the job of the mediator to identify each of those and highlight those for the parties. You also always have to address the client needs and position. I always, as an advocate, I always tell the mediator what I need. What do I need to help the client? What do I need for them to do to help my client get past a certain obstacle that they have with respect to resolution? This is an ideal way for you to be able to communicate that to the mediator. And this is the place that you can do it at. The other part of this that I think is sometimes overlooked is establishing a rapport with the mediator. I think, first of all, I think in the practice of law, as part of our profession, I think building a rapport and building trust with anyone is really important. Your credibility and your professionalism and your ability to be direct, even though it's something that someone may not want to hear, I think is very, very important. I think it demonstrates your ability of a professional when you can build that rapport with the mediator, and you can also admit sometimes that, your position on a particular area, may not be as strong as you think, but the client thinks it's strong. And this is where, Mr. Mediator, I need your help in identifying for the client that it may not be as strong as they think. I can't tell you, we talked about building a rapport with the mediator, right? I can't tell you how important it is to build rapport with opposing parties in counsel. Great lawyers, great professionals, those that have been doing this a long time, they try cases, they don't try lawyers. I think you're much better off building rapport and making a friend out of your opposing lawyer. I'm not saying that that's at the expense of your client's interests. I'm not saying that at all. But at the end of the day, cases get resolved, and you want to be somebody that makes friends in the practice rather than makes enemies. I think building rapport with opposing lawyers and their clients is really important. I think in order to do that, if you can find common ground and begin the definition, begin conversations by identifying where you agree versus where you disagree, doing it in a collaborative tone. I think in mediation, one of the issues that is super important is we don't have our advocacy hat on. We have our conciliatory hat on. We have our mediating hat on. We have our collaborative hat on, because we have different interests. We're trying to get to yes. In order to get to yes, being the bulldog litigator advocate is not always the best way to do that. So you need to find the common ground. We talked about this in the win-win mindset. What do we agree on? What do we disagree on? And if we disagree on something, is there a part of what we disagree on something that we can agree on? That is key. That is key. Also, being an active listener. You've got to really listen to be a great negotiator. You have to be able to listen to certainly be a very fine mediator. But show some interest in the other side. Show them that you're not just being flippant with their position, but you're understanding it. You're hearing it. You're digesting it. You may not agree with it, and 99% of the time, you're not going to agree with it. But there's always something in what they say that you can latch onto that can help you build the common interest, what you have in common versus what you disagree upon. I think this goes without saying. I think respect and professionalism is very important. I think those that are not respectful and do not exude professionalism, I think that's, first of all, I think that is very unfortunate. I think as professionals, like I said before, we try cases, we don't try lawyers. Always be respectful, always be professional, always have the proper professional demeanor, even if you have a disagreement. I'm going to tell you a little story. So I was an advocate in a case, a very contentious case that was being mediated by a very, very fine mediator. We were all together, just lawyers. Strike that. Clients were there too. I'm sorry. Both clients and lawyers. And I began to get a little heated with the other lawyer. And the other lawyer used vulgarity to me in front of my client. And I just, first of all, I was shocked. But second of all, I just stood there and I said to him, I said, what are you thinking about? And he backtracked and said he was very sorry. It was the heat of the moment. He was sorry that he did that. You can never, ever, and by the way, the next day he called me, apologized profusely, and I accepted his apology. I knew it was in the heat of battle. I knew he didn't mean it. I knew what kind of lawyer he was for many, many years and his reputation. But you just can never allow that to happen. You always have to maintain yourself, maintain your composure, maintain your professionalism. Your reputation is on the line no matter who the client is, no matter who the case is. Your reputation will carry you throughout your legal career. And by the way, just a snap of a finger, it could be gone. So always remember that when you are negotiating and building rapport with opposing parties. Well, this is another topic that I could spend an hour on because I love this topic. It's so important in any negotiation. It's so important in mediation. It is the nonverbal communication in negotiations. Nonverbal. I always tell younger lawyers, it's not always what the lawyers or the other side or the client says or indicates. It's what they don't indicate. It's what's not said that very often is very, very, very important. So what do we look for in nonverbal communications in negotiation? Like I said, this is a topic I can talk about for an hour, but obviously our time restraints don't allow me to do so. So I'm going to try to get through it as quickly as I can. But this is so important. Body language. You have to, first of all, in any negotiation, in any mediation, you have to be absolutely focused on the parties, on the mediator, on the lawyers, and you have to watch them. You have to watch their body language. You have to watch when you say something, how they react. Are they in an open position? Are they in a welcoming position? Are they in a defensive posture? How do they react to something that you say? Many times, as an advocate, I will say something intentionally because I want to see their reaction. I want to see their counsel's reaction. I want to see what they do. Is there a sigh? Is the head down? These are all key body language awareness techniques that you must be aware of. You must be conscious of. You must always pay attention and pay particular attention of what happens when someone is speaking. And it's not only you, it's also when their lawyer is speaking, and it's when the mediator is speaking. Many times when the mediator is speaking, I'm watching the other side. I'm also watching my client to see whether or not the mediator is resonating with the client. Tone and voice control. You know, when you are in control and when you are calm, that tone conveys confidence and conviction. It also reduces the tension in any discussion. So your tone and voice and inflection of your voice is just so important. And many times lawyers try to get dynamic, and that's okay. But remember, this isn't necessarily closing argument to the jury. This is the art of communication. This is the art of messaging. This is the art of connecting. This is the art of building trust and rapport. These are the secret sauces in order to get us, in order to identify nonverbal communications in negotiation. As I said before, be observant. You have to be extremely observant. You have to watch everything, every single move, eyelids moving, grabbing of the hair, crossing of the arms, the sigh, the facial expressions, posture, because all of these are going to tell you and give you cues as to what is happening inside that person's head, inside their brain, inside their mind. And in order to be a great negotiator, the key is information. The more information we have, the better negotiators we can be. The key is always information. We talked about this a little bit before, and I'm going to get through it somewhat quickly because we have about 20 minutes left. And so I want to maybe move through this part a little bit quicker because we have talked about it. So obviously cultural norms are important. You need to research them. You need to identify them. Identifying potential barriers. You need to be aware of language barriers. You know, do you need an interpreter there? Is that going to be important? Is the interpreter going to interpret it the way that you communicate it? That's also very important. And you always have to tailor your strategy that respects the cultural sensitivities in order that there's a fair process for everyone. Communication strategies for cross-cultural mediation. We're going to go through this quickly as well. You always have to adapt the communication styles. You need to adjust your approach to match the cultural expectations. Clarity and confirm. Many times when you're dealing with others that may have some challenges as it relates to communication, you have to ensure that what you communicated was communicated accurately to them and that they understand. Also, cultural respect. We must demonstrate respect for the cultural differences that we may have from the other side, or even our clients in some cases. Okay, very important topic we're going to deal with right now. And that is the ethical considerations in negotiation, which I know all of you on this take very seriously, as do I. Um, you know, one of the issues is to avoid manipulative tactics, right? Withholding of key information. It undermines trust. I can tell you as a mediator, when I see one side trying to play some games, that does not help their clients. It does not help the process, and it doesn't help them. So always be forthright, okay? The approach to negotiation should be with integrity and transparency, and that's in order to obviously advance your client's position, but also it's important because it's your reputation, and you want to always have credibility with the parties and those that are involved. Maintaining professional responsibility in high stakes discussions. Always act forthright with honesty, diligence, ensuring your actions align both with the rules of professional responsibility and your client's expectations. Remember, we have a law license. We have a law license to protect. We have a law license to guard. We always must do so. Always remember that you must maintain confidentiality in the mediation process. Everyone always should be advised of this. This is a confidential process, and that to divulge information is improper. And it's also important for your clients to know that it's confidential. I had a situation years and years ago where a client, and I had told the client that this was confidential, and he leaked out some information. It got repaired and there was no damage done, but it's an issue. Obviously, conflicts of interest. Have to disclose conflicts of interest, ensure impartiality. I can tell you as a mediator that I am constantly sensitive to conflicts, sensitive to whether or not our firm represents a party or anyone connected with a party or anyone connected with their counsel. I am always disclosing, I'm always supplementing it. I do not want anyone to ever feel that I did not give them a fair shake, that I wasn't honest and forthright with them. I always tell them that. I always will tell them that. Obviously, promoting informed decision making, right? I mean, you want to provide all parties with the accurate and complete information so they can make a well-informed decision. I think this is really important. Obviously, respecting the party's autonomy, right? You want to encourage a fair and voluntary agreement. You do not want to pressure or coerce anyone. That is just not proper. It's not right. It doesn't really help you in your case. And at the end of the day, it's not going to promote or help you with regards to a resolution. Okay. Touched upon this, but I want to spend some time on this because this is really important. In order for there to be a productive negotiation or for there to be a productive mediation, it is key that the lawyers take adequate time to prepare your clients. And we're going to talk about now some client preparation strategies. What are these? What can you do to help your client help themselves get to yes? Right? It's like the old Jerry Maguire, help me help you, right? Help me help you. I say this all the time. You've got to really connect with your client, and you've got to have, in many instances, a heart to heart about, some of the difficult issues in the case, some of the problems in the case, some of the challenges in the case if you're going to have to try the case, if you're going to have to go to trial. You're going to have to establish that trust, right? where you could tell them whatever you need to tell them and not worry about any backlash. You also have to talk just endlessly about the expectations and perceptions. You have to prepare them for the expectations. If in fact they want $1 million and you know the case is a $500,000 or $250,000 case, you've got to deal with them because they are going to hear it in the negotiation. They're going to hear it from the mediator. The mediator is going to be straight up with them. Okay. And you have to identify what the client is looking for, and you have to manage those expectations. And it is better, I will tell you, it is better to tell them early the bad news than late. Deal with it right up front. Tell them, I don't think we're going to get $1 million. Even if we try the case, we're not going to get $1 million. Be transparent. Share the information that you have openly and be honest about the intentions and expectations, because I guarantee you, as a mediator, I am going to tell them directly and honestly, okay, the facts, the way I see it. I'm going to call the balls and strikes as I see it, and I'm going to tell them whether or not they are looking at this from a different perspective that's not reality. Misaligned goals. It's really up to us to guide the clients toward practical, achievable objectives, those that are realistic and mutually beneficial, right? What can we do regarding aligning our overall strategy with expectations, right? I think this is really important. You've got to make sure that the client is going into the negotiation objectively, but that their expectations are relatively real and not pie in the sky. This is really significant. The emotional involvement. Obviously, clients that are involved in litigation are very emotionally charged. They're upset. They are aggravated. It's costing them a lot of money. It's also one of the most difficult parts in your life when you're involved in litigation and when you're involved in the advocacy and environment. You are fighting. This is a fight. Okay. The other side wants the better of you. And so emotions can cloud their judgment. You have to help them focus on the facts and the strategy. Unrealistic deadlines. The other thing in preparing the client is you cannot wait till 2 hours before and have them in your office and think that you've prepared them adequately. That is not going to work. It is also going to be unfortunate for the client because they're going to have too much information to digest before they walk into any mediation or negotiation. So make sure you are way out in front of preparing them in order to give them the best opportunity to be prepared for the negotiation and mediation. Okay. Post-mediation strategies. We got a deal, right? We got to yes. Wonderful. Outstanding. Now what do we do? Well, I'm going to tell you a little story. So many, many years ago, I was involved in a mediation where we, at a late hour in the evening, we came to a resolution. And I told the mediator I wanted us to, I didn't care if it was very late, it was after midnight. I said, I don't care if it's 3 a.m. I want to sit here and I want to, and this was before laptops. So we had a typewriter, right? Or maybe there was a word processor, I forget, but it was way before computers, personal computers. And I said that we either need to write it out longhand or we get somebody to type it. And the mediator said, oh, it's late. Why don't you go home? Why don't you do it in the morning and get it signed up? Well, the parties changed their mind. Okay. Parties changed their mind. We ultimately did resolve the case, but it wasn't the next day. So here's my cardinal rule. You must document the settlement the same day that you've resolved it, even if it's just a memorandum of understanding. You need to sign it. You need to date it. You need to have the client sign it. If you want a more expansive settlement agreement to come, that's fine. But the memorandum of understanding must be signed. And you must obviously formalize them in writing to avoid any misunderstanding and provide a clear reference point. Obviously, after the mediation, many times after the memorandum of understanding, we go to a full-blown settlement agreement with general releases and mutual releases. That has to be prepared. But once you have the terms prepared and signed, that is a binding settlement. They are not getting out of it. And then you can work toward the more formal agreement, which we all do in many of these cases. Check with the clients and other parties to confirm that the agreements are being implemented. And obviously, what's really important post-mediation is that you preserve your professional relationships, right? For future collaboration and negotiation. I can't tell you how many times I was on the other side of someone in a mediation and we became friends. And then they referred me cases in the future and used me as a mediator in the future. So always make friends and establish relationships in your career. It will do you well and serve you well. Okay. We got about 5 minutes or so, maybe a little longer, maybe 6 minutes. I want to just talk about and summarize what we learned today. The key takeaways. Adopting the right negotiation mindset, the win-win. How can we identify outcomes and issues that we are aligned with? This is really important. It's important to do it with empathy and flexibility, but it's important to prepare the clients that these are the terms and conditions that we agree upon. There are some that we don't agree upon, but those are what we're going to attack in the negotiation and in the mediation. Extremely, extremely important. Overcoming the common challenges. We have to address the high conflict personality, right? The person that's banging on the table. I'm never going to settle with you. My client hates your client. We're going to trial. We're going to the appellate court. We're going to the Supreme Court. We're going to the United States Supreme Court. We will never pay you any money. How do we get around that? How do we reframe the issue? How do we keep talking? How do we deal with the power imbalances, right? In the impasse scenarios. We talked about that. Many times reframing, many times ignoring, many times getting up from the room and walking out and letting people cool down. Many times that will work. Client preparation. How much time do we spend today talking about client prep? Building trust, not preparing them 2 hours before the mediation, giving them enough time to absorb, okay, what you're telling them, giving them enough time that it resonates with them, that they can process the information. Obviously, the management of expectations and providing the tools for effective client participation. Clients are people, of course, right? They have their own viewpoints. They have their own expectations. They also deal and process with information all differently. We have to be able to manage that. Ethical and cultural considerations. We talked about this, right? There are many times that this would be someone from a different culture, a different country, in fact, a different continent, that we have to be always ready to deal with that. And let's talk about the ethical issues that we talked about. Being transparent, being direct, maintaining your reputation, maintaining that what you say you can deliver, okay, that your word is good. I can't tell you in negotiation and mediation how important that is. When people are not honest and direct with me as a mediator, it is a total turnoff. It is a total letdown. It is a total, quite frankly, it breaks down the process if you want the truth, because it does not enable people to be direct and be transparent with their positions. And that really hurts the ability to um, obtain a resolution. Advanced techniques for mediation. We talked about nonverbal communication. We talked about the idea that you have to be able to focus and extremely focus on every word, on every movement, on every reaction, on every identifiable nonverbal communication that you can pick up. That is really important. Sometimes, if you're lucky, you can pick up on a nonverbal communication that's going to allow you to settle a case. I've done it. Others have done it. And I can tell you as a mediator, I pick up on that all the time. I'm watching everyone very, very carefully. It's what we have to do. Building rapport with the opposing parties. So important. Make friends in the practice of law and establish relationships. That's one of my mantras. That's what I tell all young lawyers. Make friends and establish relationships. Implementing your post-mediation strategies, right? Make sure that it's down. Make sure that you have it written. Make sure, even if it's 3 o'clock in the morning, you have a memorandum of understanding with the key terms and conditions. You get that signed up. Then you can proceed to the full-blown settlement agreement and mutual releases. But one of the most important things to remember in all of this process is your integrity, is your professionalism, is your reputation, and that you want to make friends with the other side. Okay, even though you have adverse interest, you're advocating for your clients, you want to establish relationships and make friends. I can't tell you how important that has been for me in my career, what my mentors taught me, and what I'm imparting upon you after doing this for nearly 40 years and having a whole lot of fun. And for me, it's been a great honor and privilege to be a lawyer, and I'm really proud of it. And it's been an honor and a privilege to be with all of you today. I hope this program has helped you. I hope it will help you in your practice. And I sincerely hope it will help you with your clients, negotiating better settlements and resolutions for them and for their businesses. Thank you very much.
Thank you so much for your presentation, John. That was wonderful. We've got about 5 minutes for Q&A. So there's already a few questions in the queue, but if you have questions that you'd like to ask John, again, you can go to that Q&A button in the control panel at the bottom of your screen and submit them there. John, I'll go ahead and read off our first question. It's from
Sure.
Christian. They ask, what are some good resources that you'd recommend outside of this seminar to hone our mediation skills? Do you have any books or websites you recommend?
Yes. Thanks, Christian. And thank you for being here today. Well, I will tell you, and this was a bucket list item for me my entire career. And I wish I would have done it when I was a much younger lawyer. About 3 years ago, maybe it was 2 years ago, maybe 2 or 3 years ago, I took the Harvard Law School class on negotiation and leadership. And I can tell you it changed my career. It changed my perspective on negotiation. The Harvard Law School classes that they have online, I went to Boston, to Cambridge, It was the best course I ever took. There was 200 people in the class and there was 4 lawyers. They were all business people. And I really was able to learn how business people view negotiation, how they view what are the important issues in a negotiation. I can't tell you how career changing it was for me. I would encourage all of you, if you can ever get the chance to do it, to take the Harvard Law School class on negotiation and leadership. You will forever be grateful that you took it.
Thank you, John. Really appreciate that insight. Our next question comes from an anonymous attendee. They ask, so an aggressive posture on behalf of the client is not advisable. What would you suggest doing in place of that?
Well, you can be an advocate without being aggressive and hostile. Okay. Advocating your position, the strengths of your case, the strengths of your claims, the strengths of the circumstances that the other side has presented for you is something that you can do without hostility. Many times there's people that become aggressive and hostile. And by the way, that takes away from your persuasiveness and impact to be compelling to both the other side and to a mediator. When I hear somebody yelling at me, saying, they're wrong and this is why, I sort of lose it, right? I lose my concentration with respect to the delivery of their messaging. Remember, when you're an advocate, you want your message to resonate to the judge, to the mediator, to the other side.
Thank you, John. Our next question kind of builds on that resonance nicely. This anonymous attendee asks, what's one advanced mediation technique that you've found particularly useful for breaking deadlocks or uncovering hidden interests that parties may not express openly?
Well, I think what has enabled me to do that in my career is, first of all, I try to listen very intently to the parties and to the other lawyers. Once I listen and I'm starting to develop a rapport, they begin to like me. And if they begin to like me, they're going to trust me. And if they trust me, they're going to open up to me. And that's how I draw them out. And so it takes a lot of time. It takes a lot of patience. It takes a lot of determination. It takes being a good listener. It also takes asking the right questions at the right time. It's sort of the art. But what I would say to you is that it takes an extreme amount of patience, okay, to keep, and sometimes you just can't tear the paper all the way off. You have to do it incrementally. And that's what I would say is, I think, the best way to get underneath the surface is to allow and to build a rapport. And once they like you and trust you, they will open up to you.
Thank you, John. Our last question for today is from another anonymous attendee. They ask, how can technology such as AI-assisted analysis or virtual mediation platforms enhance or hinder negotiation effectiveness, in your opinion?
Well, I've mediated a number of cases virtually during COVID, and I've also done it after COVID. So I think the virtual mediation sometimes is harder because it's harder to view the nonverbal communication. But I think if you're very focused and you're very intense in the moment with the parties, I think you can do it virtually. I much rather like in person because I can see the entire room. I can see things developing. To your question with AI, I think AI is going to be significant in the future. It's going to allow us to get some background on the parties. It's going to be able for us to synthesize the issues. It's going to allow us to see what kind of outside the box problem solving there can be to resolve issues. So I think virtual, I've tried cases virtually. I've arbitrated cases virtually. I've mediated them. I think their virtual can be just as effective, but my vote would be for in person.
Thank you, John. Thank you so much for answering all of our audience questions. And thank you to everyone who submitted questions and feedback. We really appreciate you being here and your participation. We want to thank you all so much for joining us for another Justia webinar. As I mentioned earlier today, if you're a lawyer attending, don't miss out on the Justia Lawyer Directory, a free tool to boost your professional presence. You can claim your profile today by going to lawyers.justia.com to connect with millions of potential clients each month. And you can also explore our newly redesigned listing pages and enjoy new features on your profile, like the FAQ edition, to help you boost your visibility in AI search. And if you want even more visibility, you can check out our Justia premium placements, both platinum and gold, to help you appear above organic listings at marketing.justia.com. Thank you all so much for joining, and thank you again, John, for that wonderful presentation. Have a great day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.